Good morning, Mr. Cliven.
Good morning, Your Honor. May it please the Court, Richard Klebanner for defendant Jason Loadholt. Your Honor, if I might first just comment briefly on the Sixth Amendment firearm certificate issue as it applies specifically to this case. I know the Court's hearing a number of cases raising this issue. The Commonwealth suggested that the proper standard here is whether there was a substantial risk of a miscarriage of justice, and we are suggesting that the standard is whether there was harmless error beyond a reasonable doubt. There was no objection at trial. This trial having come after Verde and after Morales, and before Melendez-Diaz was granted certiorari. In those circumstances, I suggest, Your Honor, that it would have been extremely difficult for the defense counsel to know that he should have made an objection contrary to what was then the settled law in the Commonwealth.
That it may have been difficult, but this Court is not the final arbiter of the United States Constitution, as you know, and I think most defense counsel look to state court proceedings with federal court proceedings to follow in mind, correct?
Certainly, Your Honor, defense counsel consider both the state and the federal law, and in this case, this Court was overruled on that issue. But to say that defense counsel need to routinely assume that there'll be a Supreme Court overruling of this Court, I think it requires something of defense counsel that would lead to many objections which are simply going to be unsustainable in the long run. There are many issues which conceivably the Supreme Court may someday rule differently than this Court, and I don't think defense counsel should be expected to routinely make such objections. As to the question of whether the error was harmless, Your Honor, or whether there's substantial risk of miscarriage of justice, I would note that bullets were found in the magazine in the gun in this case. However,
was there a certificate as to the gun, the ammunition also?
Yes, the certificate covers both the firearm and the ammunition, Your Honor. It says that the firearm is an operable firearm.
So doesn't that allow, though, for the inference that it is a working firearm, the fact that there are live bullets in its
Your Honor,
chamber?
It might be sufficient to go to the jury on the issue. The question here is whether it is
the effect of the certificate.
Is whether the effect is harmless beyond a reasonable doubt, whether it did not contribute to whether this Court can say beyond a reasonable doubt that it did not contribute to the verdict. And on that issue, Your Honor, I would note that the district attorney, specifically called the attention of the jury to the certificate in his closing.
Well, was it a live issue at trial?
Well, Your Honor, once the certificates came in, it wasn't a live issue.
Well, actually, once the tests were done, it wasn't a live issue.
I'm sorry. Once the test was done and evidence of the test went to the jury in the form of certificates.
But I mean, from your point of view, or from trial counsel's point of view, the tests are done. That's the hard part. If you want to contest the tests, you certainly can do that.
Your Honor, you could if you thought that a jury was going to likely to disregard the official certificates of the Commonwealth.
Well, let me ask you this. If the certificate hadn't come in, would it have been a live issue?
I don't know, Your Honor.
Well, is it an element of the offense?
I'm sorry?
Is it an element of the offense?
It certainly is an element of the offense.
Commonwealth bears a burden, right?
But there was evidence you could infer, as we just said. You could infer from the fact that you had the bullets in the gun that it was a working firearm.
And we've said that many times.
Yeah.
The expert testimony is not necessary. A certificate is not necessary.
This Court has said that if there is a gun with a bullet in it, it's sufficient to allow the jury to infer that it's a firearm.
Is that still the same where the Commonwealth, in this case, did the Commonwealth produce a certificate that the ammunition, in fact, was live ammunition?
Yes. Well, the certificate says the ammunition is ammunition as defined by the
So your Sixth Amendment argument goes to the ammunition as well as the gun, doesn't it?
Exactly. Certainly, Your Honor.
Okay. Are you arguing that the inference that we have previously recognized about ammunition being in a gun, permitting the inference that the gun is operable, that inference is not legitimate, where the Commonwealth also has to produce a certificate or also has to produce evidence that the ammunition is live?
Well, I think it's significant, Your Honor, that without the certificate, the jury didn't know if the ammunition was live. And it's live ammunition which apparently creates the inference that this is an operable gun.
Well, there's sort of a piggybacking going on here. Can the jury infer that the ammunition is live because it was in the gun?
No one testified. When somebody testified to put that box of bullets in evidence,
Yes.
that person didn't say that they were live bullets?
No, they did not, Your Honor. And I note on that point, Your Honor, that when the gun was put into evidence, the trial judge, there was testimony from a police officer as to basically how guns work. But the trial judge specifically said he is not testifying to the operability of this particular piece of equipment. So what was left were the certificates.
Now, in the case of Commonwealth versus Doherty, which was decided in 1991, and it was one of the cases having to do with the Sandstrom versus Montana burden shifting of the malice instruction. In that case, we said that although it's constitutional error and the harmless beyond a reasonable doubt standard applies, where it's not a live issue at trial, it's not harmless beyond a reasonable doubt. Or it is harmless beyond a reasonable doubt.
I understand, Your Honor.
So why shouldn't we apply that same analysis in this case?
I think the issue here, Your Honor, is what defense counsel is faced with once the certificates go into evidence. Then the defense counsel, if he wants to make it a, quote, live issue, must try to explain to the jury why the official testing laboratory of the Commonwealth made a mistake.
But they can do that. They do it they're always asking for money for experts to contradict the Commonwealth's experts.
Isn't that essentially what is going to happen now after Melendez-Diaz? You may have a certificate. You could still have a certificate as long as you have the live body there, and the defense will be put to the task of saying that despite the certificate, the mechanism that the Commonwealth used is no good. So what you're saying is so difficult. It's exactly what the state of the law is now.
Certainly when there's a live witness on the stand, he may well be cross-examined as to how the tests were done, et cetera. But in this case, we simply don't know what would have happened if there was a live witness on the stand. And the defense counsel was simply faced with the certificates.
So he let it in. It came in. There was an assumption that, look, if why waste the money to hire my own expert when it's probably going to come back to say it's a gun? I mean, anybody can point a gun at a bucket of water and pull the trigger. That's probably what happened here, or something as unsophisticated as that.
We don't know what happened here, Your Honor. We know that
then why haven't there been contests of ballistics certificates for the last 25 or 30 years?
I would suspect that partly, Your Honor, because defense counsel feel that once the certificate is in front of the jury, they have very little chance of prevailing no matter what they're arguing.
Or
Is it that, or the test is so conclusive?
Simple, yes.
The test is so
And
conclusive,
I was
it's kind of
gonna
hard.
say, the test is so simple that, that if somebody says, I test fired the gun and it's fired, there isn't too much you can do with it.
That may be, Your Honor, but I don't know. And in this case, the issue is whether these certificates might have contributed to the verdict.
So are you arguing that the test that Justice Spina just read from Doherty is not the correct test, that Chapman's test is different in terms of what it means to be harmless beyond a reasonable doubt?
I believe Chapman, in cases following, and in fact this court, I don't have the citation, the brief has said the essential issue of harmless beyond a reasonable doubt is whether the error might have contributed to the jury's verdict.
Put it this way. You cannot take the evidence out. That's a substantial risk or substantial likelihood test. You have to leave the contested evidence in. Looking at it with it in, you then decide whether or not it could have influenced the jury, correct? That's harmless beyond a reasonable doubt.
That's my understanding of it, Your Honor.
Now, in this case, there was no other evidence that the gun was operable. The only evidence that it was operable was the certificate.
Yes, Your Honor, there was
Correct.
no evidence it had been fired, no evidence that someone had tried to, pointed at someone thinking it was operable. It was simply found wrapped.
So I take it what you're saying is even if it were not a live issue, here, because it's the only evidence that went to satisfy the element of the crime, it had to be harmless. I mean, it could not have been harmless.
Exactly, Your Honor. The jury almost certainly depended upon it to find its verdict, and we certainly don't know beyond a reasonable doubt that the jury did not depend upon it.
I have a question on another subject, the consent issue. Having read the judge's findings, which I understand were dictated from the bench and were very complete and well done, particularly considering that it was dictated from the bench, which is a practice that we encourage anyway. At one point, she did say that the woman, LaWanda Hill, Ms. Hill, told Trooper O'Toole they could search the apartment. Now, this was before the police found the defendant. So it seems to me you're arguing that there wasn't consent for the search, but there is that finding of the judge that right at the beginning, Ms. Hill told Trooper O'Toole they could search the apartment.
I think if that was shorthand, Your Honor. If one reads the transcript, what Ms. Hill said was that they could come and look for Mr. Loadholt. And to the extent that that finding suggests something differently, I think it's erroneous.
I mean, so it's limited to that, not the apartment. Is that what you're saying?
That was her initial consent, Your Honor, was to look for Mr. Loadholt. She then, after being informed that a gun had been found, gave further consent to
Look for guns.
search the apartment.
Could I ask one more question? The question relates to the question put by the trooper, I think it was a trooper, to your client when the bullet was found in his pocket. Where's the gun, or words to that effect. At that point in time, well, let me ask you this. Are you saying that in looking for him, put aside the consent and its scope, that the police were not permitted to do a sweep or a search of the apartment to see, for safety reasons, in conjunction with arresting him and being in there to arrest him?
Under these circumstances, Your Honor, when he was clearly in custody, the other occupants of the apartment...
They didn't know that. I mean, they had not... They
How
had
do they
not
know
done a
there's not
search.
another person there?
Yeah.
There were, I believe it's 8 or 9 police officers in this small apartment, Your Honor. They've gotten the mother and the young child in the kitchen, surrounded by police officers. They have Mr. Loadholt down on the ground. Other police officers are already just about completed the search of this entire small apartment.
But there's a gun. I mean, the inference is there's a gun in the apartment, and the police have not yet found the gun. So
And maybe it's next to Mr. Loadholt.
Regardless of the number of police, if there's a working firearm in that apartment, I would say that creates quite a problem for the police.
Well, first of all, Your Honor, whether...
And they don't know whether there's anyone else there.
They suspect there's a gun because they found a single bullet, Your Honor.
Correct.
I think that frankly, Your Honor, they know that they've occupied the entire apartment with police at that point.
Yeah, but they
And
haven't
there's
looked
no-
in the closet. One man's in a closet, maybe another man's in another closet. I mean, wouldn't you feel that way if you were in an apartment?
It's not a fair question.
Okay, you can't put the jury in that.
Actually, any questions are probably beyond the time at the moment.
Okay, I see.
So if I could ask one more question. Assume you're right as the public safety exception, and assume that would require us to suppress the gun, at least with respect to its being found during the course of that public safety search. I gather that after that was done, they did get the consent of the person who lived there after conferring with her mother with regard to consent. Why would there not be inevitable discovery of the firearm based on that subsequent consent, even if the gun should be suppressed as the public safety exception?
Because they get that consent by telling her they found the gun. And at that point, it's clearly the fruit of that illegal search. That's the reason she consents, because they say, we found the gun, we're worried about you and your child. I mean, we found a bullet, we think there's a gun, we're worried about you and your child. Let me search.
Okay, but they already had found the bullet pursuant to the frisk of him that was incident to arrest, so they would have always, They would have had the bullet even without the gun.
They
and
would have had the bullet, but they
No,
depend
they
upon.
had the gun when they got that second consent with the mother, right?
I'm sorry, Your Honor?
They had the gun at that point.
Yes, Your Honor, and then they get consent to.
No,
to-
they
and
had the bullet.
continue their search, and they find a box of ammunition.
Right, but at the point where the mother comes, they had the gun, didn't they?
Yes, Your Honor. They found the gun, and that's the basis for her consent.
Right, but
But I thought the Justice was asking about inevitable discovery based on the consent, and I would suggest that it was the fruit of the finding of the gun.
Thank you, Mr. Clemana.
Thank you, Your Honor.
Ms. Dillon?
Good morning, Your Honors. May it please the Court, Diane Dillon, an Assistant District Attorney representing the Commonwealth. I can start in the order that it's addressed in the brief, unless you prefer that I...
Let me ask you if, regardless of the standard, whether it's harmless beyond a reasonable doubt or substantial risk of a miscarriage of justice, if the certificate should not have come into evidence and there was no other evidence that this was a gun, that this was a firearm, the Commonwealth had no evidence, or should have had no evidence on this essential element of the offense. And isn't the defendant just entitled to a new trial?
I would suggest, Your Honor, that this was not a live issue at trial. He wasn't contesting whether or not it was a gun.
But even if it isn't a live
it's-
issue,
yeah.
the Commonwealth doesn't have evidence on an essential element of the crime. Isn't that the criteria, whether it's a live issue or not?
Well, Justice Scalia said that there can be circumstantial evidence.
Well,
And in this
what was the
case, it was
circumstantial evidence?
testimony that it was, in fact, a live round that was found in the defendant's pocket in the initial pat frisk. They compared that live round to the 3 that were in the magazine of the gun that weapon that we're talking about, the rifle. And they also compared that live round to the box of ammunition that was found in the dresser in the room where the rifle was recovered. And there is the case law that says if you can put the live round in that gun, you can infer that it's an operational gun.
But what's the inference that just because he had a live round in his pocket, that the ammunition in the box and the other ammunition was also live? How can they draw that inference?
Well, you can look at a round and tell whether, you can tell, first of all, it hasn't been discharged, it's all in one place. You can tell that it hasn't, the firing pin hasn't hit it. You can tell that it's got something in it because the weight of the round itself would differ if it were a dummy round or something of that nature. But the
Wouldn't you have to have
troopers-
evidence about that? In
The
other words-
troopers testified that they recognized it as a live round.
No,
They
I
did-
mean the other, did they testify that the 3 in the gun were live?
They testified that they were comparable. That was the testimony.
What was the evidence that the bullet in his pocket was live?
That was from Trooper O'Toole, I believe, who said that he recognized it as a live round.
Now, when you say a live round, it merely hasn't been fired.
Yes, and presumably
it
it's
would be more
loaded as
persuasive if-
defined by the statute,
But it'd be
yes.
more persuasive if they found a projectile that had been fired, would they?
Well-
I mean, if you had a revolver and indeed you could see that there was the cartridge left after it had been fired, isn't that more persuasive?
That would be much more persuasive, and it would obviate the need for the certificate because the gun would have been fired.
Because we're about to hear a case later this morning in which the evidence was plain that although that the gun could not fire the bullets which were in the gun, it wouldn't shoot those bullets.
The wrong size? you
Wrong
mean?
size. So why is it compelling that you have ammunition in the gun when it may be that that gun won't fire those bullets?
Well, they were the right size in this case. It was a .380, and those were .380 rounds. I'm just relying on the law that said before, if the rounds are found in the gun, we can,
You may
Not-
infer.
you may infer
But
that
you're
it's
not
an
compelled to
operable
make that
gun.
finding.
But this wasn't an issue. He wasn't saying it wasn't an operable
but I mean,
gun.
but isn't
He was
there
saying it's not mine.
But is there something circular? I mean, we ruled as we did in Verity because we didn't think it was worth bringing somebody in to testify because these are so rarely live issues, and we basically said if it is to be a live issue, then the defendant has the burden of bringing in. So
even if
now
that
we're
was
sort of saying, oh, it's not a live
Melendez-Diaz
issue, but that's because we
Said so.
permitted it.
But Justice Scalia said that if there's a confrontation clause issue,
course you can
the
do it,
defendant must raise it. And he said that this is just an extension of Crawford.
No, I understand that, but we're dealing with a period of time between Verdi and the granting of cert in Melendez-Diaz, right? And
That's when this case was tried.
I understand.
Yeah.
That's the difficult
I was
period.
trying to get your question,
Yeah,
Your Honor.
that's the difficult period. In other words, if it's pre-Verdi, you've got Crawford and you don't have Verdi, you clearly have to raise an objection. Post-Verdi, very thoughtful judges have said, no, it's a waste of everybody's time. The Supreme Court has said, don't do it. We've looked at it in the context of Crawford. That's what we
Everybody's
said.
dealing with this issue, but I would suggest, Your Honor, that since Justice Scalia said that Melendez-Diaz is an extension of Crawford, and that in that same case they rejected Verdi, saying this isn't business
No, of
exception.
course I understand that.
And he further said that if there's a confrontation clause issue, the defendant bears the burden of raising it. And in this case, it wasn't raised. There wasn't even something as insubstantial as hearsay, which is different from a constitutional challenge. That's an evidentiary challenge.
But if you're a lawyer in a state court and your state Supreme Court has said this is not an issue, Crawford doesn't apply to these certificates, you think that there's still an obligation on that lawyer to raise it time after time after time?
I see attorneys raising issues.
No, that's
time
not the
after-
question. The question is there an obligation?
Justice Scalia said yes.
Ms. Dillon, I don't know if you're deliberately misunderstanding. Before cert was granted in Melendez-Diaz, you're a defense attorney and you're practicing in the Commonwealth of Massachusetts and the state is prosecuting you. And the highest court of the state, which is not the last word on the United States Constitution, has interpreted Justice Scalia's decision in Crawford to say, no, you don't have to raise it. That's the issue here. Must a defense attorney then raise it, even though the court has said, no, you do not have to raise it?
With all due respect, Your Honor, after Crawford, attorneys in courts throughout the Commonwealth were aware of the fact that this was an issue that was subject to ongoing litigation, and the issue was raised, the objection was raised oftentimes.
I
The
understand.
objection was raised before Verdi,
No, it was
I would
also
assume,
no.
but after Verdi, was the objection still raised? or
Yes,
no?
Your Honor.
yes. There's a footnote in the appeals court decision saying precisely that. They looked at all of the cases. The question is not what is a reasonable lawyer doing or not doing. My question is when the state highest court has said you don't have to do. There could be several reasons why you don't do it. Why you do raise the objection, continue to raise the objection. One reason is you haven't read Verdi.
Another reason, Your Honor, might be to protect your client's rights in the event.
Another reason might be because you're really worried about federal aid because you've got immigration cases. There's been no breakdown as to asking any of those attorneys why they raised Verdi. I cannot conclude from that informal survey done by the appeals court what the reason was. The legal question we have now, and if you can find me a case that has the following facts. One, a state court of last resort interprets a United States Supreme Court decision, Crawford in this case, and says, do not need to raise it. Do not need to raise it. And then before cert is granted, by the way, in the same case, we have said you nevertheless, in all those other cases out there, have an obligation to raise it. If there is such a case, it would be very helpful. I haven't found that case. And so the legal question here is, what do we do with that category of cases?
Another analysis, Your Honor, might be in a case such as this case, where the issue was not whether or not it was an operational weapon.
It doesn't help me in this. It doesn't help me solve the. What you're saying is, in this case, I don't have to reach the issue. Possibly, I have to say I'm not persuaded, because if it is a harmless beyond a reasonable doubt standard, I have to look at it with that evidence in front of the jury. This is not a substantial risk where you take that evidence out and say, was there other evidence? Would that have worked the case? It's not. That's the substantial risk standard. It makes a big difference in this case. I can't say because I haven't looked at the whole record, but if you're under substantial risk and there's other evidence and so on and so forth, maybe there's no substantial risk. Defense counsel says, in essence, it doesn't matter which way because you don't meet either.
But there are cases from this court that have said if it is not a live issue, Spearin, for instance, then the substantial risk test does apply. And in this case, that was not a live issue at trial.
Thank you, Ms. Dillon.
You're